Those who believe in judicial supremacy believe the Obergefell holding in regard to marriage licensing laws in Kentucky, Michigan, and Ohio didn't really mean that male-female marriage licensing statutes throughout the country were actually invalid, because that would mean that Tennessee and 30-something other states would have no valid marriage licensing law at all. So they interpret what the Supreme Court said to mean that Tennessee's law and that of the other states is only invalid if the states continue to administer their law as it was enacted by their legislature. In other words, they believe that what the Supreme Court was really saying is that Tennessee needs to interpret its law as if the words male and female were no longer in the statute. The same as if the legislature had followed up and actually amended those words out of the statute, which it did not do. Or as if the words male and female really mean male or female, which would give the statute a completely different meaning from the one the legislature originally intended. However, FACT and others believe in the principles of federalism. We would say that while the Supreme Court can tell a state that its law is unconstitutional, federalism prohibits the court from telling a state how it must interpret its own statutes. That's the state's job. Do you agree with FACT and others that federalism prohibits the Supreme Court from telling states how they must interpret their own statutes after and in light of one of its rulings in another state?